panelists, and then we'll open it up for everybody. Ms. Farris, welcome.
Thank you very much. My name is Jess Farris. I'm Policy and Advocacy Counsel at the ACLU of Southern California. Thank you very much for giving me the opportunity to speak today. I've really appreciated hearing everyone's thoughts, and I'm looking forward to offering some of my own. So first, why should we care about law enforcement use of drones? Law enforcement already has helicopters and other aerial surveillance. What is the big fuss? Well, there are three differences between drones and other aerial surveillance that really highlight the differences between each in their ability to infringe privacy rights and free expression rights. And those are, one, that drones are incredibly invasive, two, that they can be very surreptitious, and three, that they can be very widely deployed. So invasiveness. Drones are already small and maneuverable enough to be peering into windows of houses or flying into houses undetected. They can be outfitted with very intricate surveillance technology like a cell phone sniffer that intercepts information from cell phone towers or invasive biometric tracking data, high zoom lenses, infrared imaging, piercing imaging that can pierce through the walls of a house and see heat and light. There are distributed videos that can allow a swarm of drones to collect comprehensive information and video analytics that can help make sense of it all. So these are capabilities that distinguish drones from the planes and helicopters used in cases like Dow Chemical and other Fourth Amendment jurisprudence that we currently have. Second, drones are built to be surreptitious. If a woman is in her backyard, behind her high fences, sunbathing nude or gardening nude or whatever floats her boat nude, and a helicopter goes overhead, she can hear the blades of that helicopter in pursuit of a suspect and take action to grab her robe and cover herself for privacy. But if there's a drone furtively flying overhead, she doesn't necessarily know to take steps to prevent images of her body from being captured. Currently in development are drones as quiet as a mouse that can hover and observe silently and constantly and very secretively. So the invasiveness and surreptitiousness of drones is augmented by how inexpensive they can be, as was referenced by Sheriff Dunn. Law enforcement is pretty constantly touting that these are, we can save more lives with a lot less money. So why does this lower cost make a difference in privacy calculations? Well, by dramatically reducing the cost to acquiring information, we remove a natural barrier to abuse, which is resource limitations. Tailing a suspect 24/7 by conventional means is hugely expensive, so it's only done when it's absolutely necessary, when there's a very good reason. But drones are not that expensive, and they can be deployed more widespread. And when that natural barrier to abuse is removed, we need to put in more safeguards for privacy. So this is why drones present a qualitatively different form of intrusion than other types of aerial surveillance, and why we need legislation that anticipates the quick evolution of technology, because that's what evolution does, or what technology does. It evolves, it marches forward. That's why this phone is so much cooler than the one I had in 2006. It's going to keep going, and so we need to anticipate that there's going to be cheaper, more sophisticated monitoring, and really see that that's going to go far beyond the police powers in the past. So what are our privacy concerns? One, drones can enable dragnet surveillance. The Supreme Court has recognized that modern technology and the ability to aggregate data can infringe on our privacy rights and really reveal a ton about us in a way that technology could not before. The court has held in U.S. v. Jones for a variety of reasons that using a GPS device to track a vehicle on public roadways without a warrant was unconstitutional. Recently also in Riley v. California, the court held that law enforcement could not search a camera without a warrant. But it should be kept in mind that for years, law enforcement was using GPS tracking and was searching cell phones, even though privacy advocates were saying, hey, you need a warrant to do that. And so we need to be mindful that it might take the Supreme Court, possibly a decade to step in and settle this debate. Drones allow for surveillance that's as persistent as the GPS tracking in drones, and could obtain data as sensitive and intimate as on the phones protected in Riley. So to avoid privacy invasions, similar to the people who had their cars tracked and their cell phones searched, we need, again, legislation to step in and adapt for us. Chilling effects are another big concern, as the court has recognized on numerous occasions. Awareness that the government may be watching chills associational and expressive freedoms. If there's a police drone hovering overhead, you might change your behavior, and that's threatening to your rights. Mission creep is a big one. Even where drones are envisioned for uses like search and rescue, they're likely to be quickly embraced by law enforcement for other more privacy-infringing purposes. So today it's bomb detection, and tomorrow it might be hovering over a high-crime neighborhood to see if anybody's doing anything wrong or monitoring a political protest. And with NSA spying revelations and growing community understanding about not only privacy concerns, but also surveillance abuse, the public is no longer willing to just bite this, hey, just trust us approach, and they shouldn't. In San Jose recently, the police department told City Council that it was approving drone use for hazardous material investigations, but then later decided it wanted to use it for any purpose that could threaten public safety. And in Alameda, the sheriff repeatedly told the public and the Board of Supervisors that the drone his department acquired would be used for search and rescue, but then he certified to Cal EMA that the drone would be used for law enforcement, terrorism, prevention-oriented activities. So I'm not sure how search and rescue can prevent terrorism, but I do see that this kind of latitude and this mission creep shows us that uses can rapidly expand. And not only that, they can devolve into warrantless surveillance if we don't have clear restrictions for use in place. Abuse and discriminatory targeting are also concerns. Abuse can take the shape of voyeurism. In 2004, a couple was having relations on a nighttime rooftop deck where they had every reason to expect that they were in privacy. It was a private balcony, and they were filmed for 4 minutes by an NYPD helicopter using advanced night vision goggles. We have to keep in mind that people will be operating these drones, and people are flawed, and they bring to work every day their biases and their prejudices. Experience also teaches that surveillance can be used in discriminatory fashion. In Britain, for instance, where video surveillance is pervasive, studies have constantly shown that the young, the black, and the male are systematically and disproportionately targeted, and not because of their involvement in any sort of crime or disorder, but quote unquote for no obvious reason. And as we recently saw from Glenn Greenwald's revelations, at least 5 American Muslims were monitored by their own government for 6 years. So this is the kind of abuse that could become commonplace if drone technology enters widespread use. So how do we protect Californians? We enact meaningful legislation that protects civil liberties. We don't need to wait for the courts. Congress didn't wait for case law to develop, for instance, on wiretapping. They took quick steps to pass laws. And as Justice Alito stated in his Jones concurrence, and we agree, in circumstances involving dramatic technological change, the best solution to privacy concerns may be legislative. So legislation should ensure that there's transparency and public debate about the fiscal and civil liberties costs in communities before funding is sought and well before any drones are acquired. Decisions should be made at the local level by civilian elected leaders, because communities are in the best position to know what their communities need. And if drones are going to be used, which in many cases they probably should not be, there need to be robust enforceable safeguards about purpose specification, data retention, dissemination, minimization, and absolute prohibition on weaponization, a warrant requirement so that we do prevent mass warrantless surveillance, and also audits to make sure that those rules are being followed. About a warrant requirement, I think there's been a lot of consensus, and Professor Volek, I don't know if you're still in the room, maybe not, but we agree with him, and he is my personal law hero, so I was very excited to be speaking on a panel, the same panel that he was. But law enforcement should get a warrant in order to collect and use previously collected data. This is a time-tested and robust protection that's consistent with the U.S. Constitution, the California Constitution, California case law, and it's also beneficial for law enforcement. It's easily administrable. It relieves law enforcement of the opportunity or the uncertainty of their actions while we're waiting for courts, and it also relieves the risk that courts will exclude drones-based evidence in a criminal trial. And finally, there need to be strong auditing, oversight, and accountability mechanisms, because I think law enforcement doesn't always have the time or necessarily the willingness to be voluntarily transparent for a multitude of reasons, but the best safeguards in the world are meaningless if we don't know whether they're being followed or not. So in conclusion, drones pose whopping new freedom of expression and privacy intrusions, and if criminal law enforcement and intelligence gathering is going to be using drones, then legislatures need to enact very stringent requirements for when that drone use can happen, and also clear warrant requirements so that we can protect all of our citizens' rights. All right, thank you, and I'm happy to take questions as well.
I'll ask Ms. Farris a question just because it's, we have lots of participation now by civilians who have these 24-hour cameras there, and they share the information with police and law enforcement. Other than being more invasive and surreptitious with drones, can you make a legal distinction between civilian proffering of information to law enforcement and our concern that we as a legislature should pay attention?
Yes, I think you should pay attention to that, because if you don't, there's a huge loophole through which law enforcement can acquire information or target a suspect without probable cause and articulable reasons that they're targeting a suspect. So I think there should be legislation and immediate, robust restrictions on sharing information. I know that there's legislation that is currently saying, you know, if you are collecting information, it needs to be for your core purpose or your core mission, and it cannot be shared with law enforcement, because that would be a huge loophole that we don't want to leave gaping.
Mr. Wagner.
Yeah, I was struck by something Captain Dunn said, and I guess I want to explore it a little bit more and maybe get Ms. Farris's take on this. You said that in your pilot, for lack of a better word, program, you solicited a lot of public input, and the public was all fine and dandy with what you were proposing. I hear from the public, they don't like red light cameras. And this is going, you know, in my mind, significantly beyond that. So I guess my question is, what sort of questions were asked of the public? Did they, you know, get an opportunity to opine on the issues Ms. Farris is talking about, the potential privacy implications, as opposed to just, do you want something cheaper and quieter than helicopters to stop the, you know, the wild car chases and what sort of stuff? And to Ms. Farris, does the ACLU participate when folks like the Ventura County Sheriffs, or maybe in LA, open their issues up to the public? Are you at the table or at the supervisor's hearing? So let me ask along those lines,
Most of our public input came from panels that were brought out to see demonstrations of scenarios usually using the device, and it was feedback from those demonstrations.
We have been invited. I think Los Angeles Police Department's pursuit of drones has been kind of everything that privacy advocates, save for the fact that they're wanting to use drones, would be asking in terms of acquiring new surveillance technology, that they're open, that they're transparent. They invited us to the table, and that didn't necessarily mean that we agree or that we think that the beneficial uses of drones could outweigh the privacy concerns, but we will tell anybody. We agreed to go because we will tell anybody what our concerns with drones are. We're happy to do that. But I mean, in many circumstances, there's a huge lack of public transparency and public accountability, and also the opportunity for the public to weigh in, and that is very problematic, not just in California, but across the country.
Well, and do the folks from law enforcement agree there's a lack of opportunity for the public to weigh in on these issues? Because I'm not sure you do, but I'm curious.
We haven't, the Los Angeles Sheriff's Department hasn't held a public hearing on anything like this yet. We haven't gone down that road that far, but it's a large county, a lot of different residents, a lot of different areas. So it would be difficult, but we would definitely take every attempt to get as much public input as